I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today, we are jumping into our 37th compilation video of some classic moments that we've shared here on the channel. Today, it will be 3 different judges' courtrooms that we will be in. But before I name those judges, let me just inform you that there will be no commentary at the end of these proceedings. Also, there will be chapters added just in case you need to jump around from case to case. With that being said, let me give you the rundown of the judges' courtrooms we'll be in today. First, we will be in the courtroom of Judge David Wolfe out of the state of Tennessee. Second, we will be in the courtroom of Judge Sean Perkins out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Kalo Wilcox out of the state of Washington. As always, guys, I appreciate the support. I appreciate all of the comments that you guys have been leaving in the comment section. It has been really good stuff. A lot of great points that's been made. I don't know why I'm all stuttery today, but just know that I appreciate you guys. And thank you once again for joining me for another compilation. And with that being said, guys, let's go ahead and jump into these proceedings.
All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent in the area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me. Apparently there's a copy here.
Yeah.
All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel. waiver and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent and error signature.
All right. Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an article pre-trial?
To what?
Will that be an article pre-trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this. And I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem with the jury warrants? If you put a notice up there for tonight, if we don't need you tomorrow, but we need you on February the 6th. Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry.
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me, whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be set, will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business. 2021 CR 19158 State versus Matthew Aldridge. All right. I've been handed a document that states, I, the attorney of fact, there is a ruling $25. I'm asking what form of exchange is acceptable. Also, is the trial going to be about trial by jury on the 15th of July? Only a bar member is able to respond by mail. Bill, Tennessee, United States of America, zip.
Well, my address, the address.
Pardon?
Rather have the address private, with you, of course.
Up so I can make sure I'm here. You're going to speak up. We've run through this before. Are you, in fact, Matthew Aldridge, acting as your own attorney?
I'm, in fact, I'm the attorney, in fact, for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Right. Now, you understand Matthew Aldridge is required to be here today because his trial is next week. And if you are Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement. Otherwise, you're going to go to trial next Monday, is it?
The 15th.
All right. You'll be going to trial, and it will be a jury trial. And
Yes,
you're
okay.
going to represent yourself, correct?
Correct. Yes, correct.
All right.
Correct.
And we will show that you are to be here Monday. How? Raise your right hand. Let's place you under oath. I just want to ask you a few questions on the record. Raise your right hand. Let's place you under oath.
Yeah, fine.
All right. How old are you?
I'll be 40 this August.
40. All right. And how far did you go in school?
I graduated.
All right. From high school?
Yes,
All right.
high school.
Have you familiarized yourself with the rules of criminal procedure?
Yes, I have been.
All right.
Yes,
So you understand what the rules are regarding a trial. Do you also understand what the rules of evidence are regarding a trial?
Correct.
And you understand that you're going to be held to the same standard, acting as your own lawyer. You have every right to represent yourself, and I'm not saying you don't. I'm just simply saying you will be held to the same standard that any other defendant will be represented by an attorney. You understand that? You have an absolute right under our Constitution to have an attorney to represent you. And if you could not afford one, I could appoint one for you. But you have elected, if I understand correctly, to represent yourself and waive your right to an attorney. Is that correct?
Correct.
All right. Then we will see you. I'm going to ask that you sign this written waiver. Sign right there where the X is. Pardon me. All right. I got it. Right, you have signed this without prejudice. Is that your name?
Without prejudice?
Yeah, is without prejudice your name?
3-301. Would you like?
Now, understand, we're not going to mess around when we come back next week for this trial.
I'm aware of
not
that.
Up with any kind of foolishness where you don't identify yourself. Matthew Aldridge is the defendant. I know you are Matthew Aldridge. You're going to go to trial next week, and you're going to have to be in front of a jury of 12 citizens. We're going to pick a jury. We're going to try this case, and if you are found guilty, then you'll go on to appeals court, and then you'll have a right to an appeal.
Yeah.
But if you come in here and say that you are the attorney of fact or that you are without prejudice or whatever the situation is, you understand that I'm not going to put up with that kind of foolishness in front of a jury. You're going to have to represent yourself, but you're going to have to come in here and adhere to the rules. Do you understand that?
Correct.
And that is the ruling of the court. I'm going to show that he has signed this without prejudice, but I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for a waiver of his right to counsel. We will see you on the 15th day of July, 9 o'clock. The witness problem, the state has indicated that they may be wanting to dismiss the case against Matthew Aldridge. But Matthew Aldridge has not appeared in this court officially. So what I want you to understand is this: you can play this game with trying to say that you're the attorney of fact or whatever. And if you persist in doing so, the only choice I have is to issue a failure to appear warrant for Matthew Aldridge. And if you, under oath, tell me today that you are in fact Matthew Aldridge, then we can take steps to try to resolve this matter. So it just boils down to, if you want to stand on your procedures, then what I'm going to do is, and you refuse to identify yourself as Matthew Aldridge, then I have no choice but to issue a warrant for failure to appear against Matthew Aldridge. And I'll have you step back with the officers, and they'll try to identify whether or not you are or not. You cannot defeat the ends of justice or the justice system by simply trying to say you're not who you say you are. So,
may I speak?
yes, sir. Put that microphone up so we can make sure that. There you
go. By appearing in attorney in fact, I am protecting my Fourth Amendment right.
Your Fourth Amendment right.
Yes.
What right under the Fourth Amendment are you asserting?
I have the right to my own private property, and I don't have the right. I do not have to give my name. It's basically the Fifth Amendment too. You're establishing evidence against yourself.
And I've explained to you what's the process is going to be today, correct?
I am aware. I am Matthew Aldridge, as described in the criminal complaints I've set out.
Hold on just a second. Raise your right hand and let the clerk place you under oath.
Okay.
You solemnly swear that you will be able to yourself all truth and nothing but the truth.
I do.
All right. Now, are you Matthew Aldridge, the defendant in this case?
I am Matthew Aldridge, as described in the criminal complaint that I sent registered mail on Thursday against the witness.
I'm not sure that we have received anything.
Yes, the witness.
We haven't received anything. What exactly were you saying?
It's registered mail. I have my tracking number. It's at home. It is registered mail. It went out Thursday from.
So you're using the government entity or a semi-government entity of the post office registered mail to send something to this court?
Well, every time I've stated something on the record in the clerk's office, you've always asked, I haven't seen nothing in the mail. And so I figured that's where you'd be looking for it.
All right. Well, you have identified yourself as Matthew Aldridge, the defendant in this case. And therefore, General Willoughby had indicated that he was going to dismiss this case based upon a witness issue that the complaining witness or the state's main witness was someone who is no longer with the law enforcement here in this area and was not willing to return based on issues that had happened. Is that still the state's position? All right.
Yes, Judge.
All right. Then Matthew Aldridge, now that you have identified yourself correctly as the defendant in this case, then the state is moving to dismiss the charges against you because of a witness problem. Case is dismissed. You are free to go.
Thank you, sir.
All right, where are we now?
On Lynch, we just sent a request for a different attorney. It was his request, and I understood his request, so we're just hoping for a different attorney.
All right.
But I think if I'm understanding our conversation, he does not want a jury trial. Mr. Lynch, was that correct?
No, I'm gonna give him a jury trial because, listen, he's already filed. Where's Mr. Lynch?
Right here.
All right, let's go back on the record with Mr. Clyde Darnell Lynch. Mr. Lynch, turn your camera on.
That's what I was trying to figure out.
I'll give you a prompt.
Okay, hold on. Here you go.
So he's already filed a lot of things with me. And we've had a long discussion about what he's filed and the legalities of it. I don't find anything that he's filed that has any merit. So that's why I'm giving you a jury trial, because if you bring the same stuff in a trial, if it's the same as what you're giving me and the stuff that you're professing, based on what I see, you're gonna lose.
So
By me.
If the judge is saying the information is not valid and the people don't know nothing, so why won't I put my hands in the hands of the people?
Because first of all, what I'm telling you is I'm trying to give you a fighting chance with these arguments that you're making. What I'm telling you is you're not going to have a fighting chance with me. You're going to lose unless you come with something substantially different than what you have. At least with the people, you said it yourself. They don't know the law, or they might not even know the law. So you may be able to get them to side with you just because they love Mr. Lynch and they want it. I don't know. But other than that,
no jury. I really don't know people jury. I'm not even gonna do that. So if I found guilty, so I'm gonna have to sue every person that was a juror.
I don't know what you're gonna have to do. I don't know, Mr. Lynch. You're the one that's making these arguments up, and you're the one that has researched and done what you've done. You provided that stuff to me, so you're expected to know the law. You're expected to know the law. So whether you can sue jurors and whether you can sue whoever, that's going to be on you to know, and then or if you don't know, that's going to be on you to find out.
Okay, so I have to get back with the law department about the videos and the dash cam of the police officers.
That I can Mr. Bowman, can you put your appearance on the record, please?
Honor, Mr. Bowman, for the people, P33764.
All right, now, Mr. Lynch, now I can potentially help you if the stuff exists. Mr. Lynch is asking for body cam and whatever discovery that body cam, audio, video, whatever discovery that the people have in relates to his matters.
Your Honor, I understand that, and discovery would be provided if he files a valid request pursuant to the court rule for discovery.
So you saying I haven't done that previously? I don't send it to the law.
Hold on, Mr. Lynch. Your Honor, if I'm not mistaken, the court rule just says upon request. He's made his request today. I don't think that there's anything in the court rule that requires anything other than him making a request. Mr. Lynch has made his request for discovery, and I believe it's supposed to be provided to him.
Court rule provides for a written request, and that has not happened.
All right, let's the discovery, rule 6 point. We're gonna know this discovery rule, and you got it ready.
Forward and backwards.
Yeah, you need to get this book. You need to get this book, Mr. Lynch.
It doesn't say in writing, though.
In addition to disclosures required by provisions of law other than MCL 767.94A, a party upon request must provide all other parties the names and addresses of all lay and expert witnesses whom the party may call at trial. In the alternative, a party may provide the name of the witnesses and make the witnesses available to the other party for interview. The witness list may be amended without leave of the court, but we need to start putting the witness list together too, because a witness list needs to be filed too.
Yes, Your Honor.
Go ahead.
Nowhere in there did it say in writing. It said upon request. It didn't say it had to be in writing.
That's what it said, Mr. Bowman, and I'm taking notice that he's requested discovery.
Well, so this request will be from what is today's date? September 9th?
9th.
And yes. the court rule provides a certain allot of time.
Technically, Your Honor, unless the court says otherwise. So it could be a shorter period of time than 21 days. If we're going to use the rule, we got to use it both ways. It doesn't necessarily say it has to be 21 unless the court says otherwise. The court could tell you today.
No person has filed a document with the city of Detroit. It is my understanding that any documents that have been filed directly with the court. That's improper. That's number one. Number two, the court rule, as I understand it, provides that we have 21 days. Unless
otherwise ordered by the court.
I'm not finished.
I know, but if you're gonna quote it,
I'm not finished.
Wait, stop. Let him finish, Ms. Harris. Let him finish. I'm gonna give you opportunity.
Court rule provides for a specific number of days. If the party wish a shorter time, that could be granted if that is good cause to not have to abide by the court rules. Those things have not happened. They haven't sent it to the judge, and they haven't sent it to me, an attorney for the city of Detroit. And Ms. Harris, who is assigned as House counsel, hasn't filed an appearance that says that she is representing this gentleman. As a matter of fact, I believe Ms. Harris got up on here to say that she really didn't want to have anything to do with this person.
Okay. Are you done? Are you done, Counselor?
Thank you.
Let me say. Can I say something? Huh?
Sure, but I do get a turn, right?
Can I say something?
Go ahead.
6.201, capital letter F, timing of discovery. Unless otherwise ordered by the court, the prosecuting attorney must comply with the requirements of this rule within 21 days of a request under this rule, and a defendant must comply with the requirements of this rule within 21 days of request under this rule. So I'm going to give the city the 21 days that they allot. I'm not going to order any time greater. I think that since we're going on a jury trial December 10th, 21 days is a lot of time. If he gets it in on the last day of the 21 days, is a lot of time for Mr. Lynch to prepare. So that's going to be the order. Get the discovery within 21 days. And there's a reciprocating discovery rule, Mr. Lynch. If you have anything, these motions that you filed, he did indicate, Mr. Bowman, that he did try and get those to the city attorney's office. He did say that earlier, but I don't know if he was successful or maybe it was one of your other colleagues or not, because I know Ms. Mason was in here the last time. Anything else?
No, Your Honor.
Go ahead. Hearing no response, let's go ahead, Ms. Harris. Do you have anything else?
Nothing. I'm not going to be that person today. Nothing.
Ms. Harris does not have to file a, she's just here for the House Counsel today, and no attorney files any appearance like
Well,
that.
I will say I technically did put my appearance on the record, so
You did.
I made the request on his behalf. And I didn't like, well, I do have to clear the record there, the mischaracterization of what is actually transpiring with Mr. Lynch's case. I did not say that I didn't want to represent Mr. Lynch. That was a conversation that he and I had privately where we discovered that there's potentially a conflict of interest, and he has requested that a different attorney would represent him. So I just wanted to make sure that was clear for the record. I don't need anybody to speak for me and what happens with my clients. Thank you.
Mr. Lynch, you got a very good lawyer here. I'm talking about very good lawyer.
Conflict of interest. Trust me.
He's correct, Your Honor. He is correct.
All right. If it's a conflict of interest, I'm the one that makes the determination of conflict of interest. But I'll allow it to go. You know, we'll get you another lawyer. And this is not, I'm not going to keep appointing lawyers to you now.
I understand.
Right? So you know, if you have a conflict with the next one, that's just going to be your problem. You go hire a lawyer after that. Can we get him another lawyer, please?
Oh, she's working on it.
Okay. Pass them out. Let's get Mr.
67.
Clyde
64.
Lynch.
61.
Let's go lastly back on the record with Clyde Lynch. I've given you an opportunity. Now this is the second lawyer. I set a jury trial for, I set a jury trial for December the 10th. And did y'all have a conversation?
Yes.
All right, so I'm going to set a final pre-trial for any motions, and you see the motions that he's put in this file, haven't you?
I've seen them.
And he can forward you those motions as well if you need to. And you need to get a copy of those motions to the city, of course, please. All right. Let's set a final pre-trial for.
You like me, that's why you get it.
Let's set the final pre-trial for December the 9th. And make sure everything is going to go on that date. Let's make sure we have our officers going to be there then. All parties need to appear. That's including your officer, Mr. Bowman, because I want to make sure that we don't order this jury and then there's someone not going to be here. So that means that if the officer doesn't show up for the final pre-trial, the case is going to be dismissed.
I understand, Your Honor, and this final pre-trial date is what?
It's going to be the day before trial, December the 9th. I want to set a motion date. Let's just say motions by the people are going to be due by motions by the defense, motions due by the defense by November the 8th, and responsive motions, if any, are going to be due by November the 15th. All right, anything further, Mr.
Lynch, do you have anything else?
Okay, so what's going to be due on the 15th?
No, the judge, if I can.
Go ahead.
On November the 8th, our motions are due. The people's responses are due 7 days later on the 15th. So any motions that we want to file need to be submitted by November the 8th. need to be filed with the court and also submitted to the prosecution.
And then and then I'll rule on the motions on the final pretrial date if I need to, if everybody shows. Mr. Ogletree, can you put your appearance on the record, please?
Yes, Aaron Ogletree, P number 69167.
Now, are we square on everything?
Yes.
Mr. Bowman?
Yes, Mr. Ogletree, could I have a phone number from you, please?
I'm going to go to your office right after.
Oh, okay, cool.
And he requested discovery as of today.
As of today, I understand.
I put forth a written request. I'll get back to my office.
Very well. All right, that's it. It's concluded. And Mr. Lynch, have a very good day. Best of luck to you. All right. Thank you.
All right, you too.
All right, thank you.
I'm Ty Warren. Mr. Warren is here. He currently does not have an attorney appointed.
Mr. Warren. Mr. Warren, you want to come on up and, all right. You want to have a seat up here? Or would you rather stay where you are?
I'll stay here. Then.
Okay, that's fine. We can still hear you and communicate well. So we're taking up the case 24 on 130. And Mr. Warren, you've filed this motion to dismiss the state's charge. And I've had a chance we were together, I don't know, a few weeks ago, and we set this hearing. And so I'm going to turn to the state here. I don't have anything filed.
That's correct, Your Honor. And when I was reviewing this late last week, it came to my attention that nowhere in the record did the court authorize the defendant to proceed pro se. And the issue the state has is we haven't provided discovery to the defendant. We haven't provided discovery to counsel for the defendant. And until he's authorized by the court to go pro se, we can't really respond to his motion either.
Well, I think we're at a motion, and this was filed in February. And since April of 2024, it's been clear, Mr. Warren, who's also to us known as Mr. Azeltine, but Mr. Warren is proceeding representing himself. And he's made it very clear in his pleadings, and I'll allow that. And it's been allowed throughout. So are you going to respond to this motion today?
I can respond orally to the motion, Your Honor. Yes.
Okay.
I do have to express some hesitation and concern here, Your Honor. The state currently has a case coming back from a Superior Court appeal where the court did not go through the pro se properly with the defendant, and therefore the court is overturning that case.
Well, this goes back to a filing of April 2024. I haven't looked through all of the recordings, but I think Mr. Warren, I think it's been clear that you're wanting to represent yourself since this beginning. Is that right?
Yeah, let me make that clear. Without recourse, as my unrebutted affidavit on file in this case stipulate, I am not the ends leeches, Mr. Azeltine. I'm not Mr. Warren. I'm a man. My mother called me Ty Warren, and I'm of the Azeltine family. Sovereign as spoken of in David Wolfe versus Hopkins, and not the corporate artificial entity Ty Warren Azeltine in all capital letters, nor representing the defendant, Ty Warren Azeltine. I'm not here pro se. I'm here by special visitation, sui juris, in propria persona. You may call me Ty Warren.
Okay.
I'm here under duress and threat of arrest by special visitation, reserving all rights without prejudice under UCC 1-308, and refusing any contract not explicitly agreed to. For the record, I do not consent to the court's general jurisdiction over my person.
All right. So you're in a criminal court and you have the right to be represented by an attorney or to represent yourself, to speak for yourself, put it that way, and not have an attorney represent you. So where are you?
I'm here to present myself as a man,
Okay.
not as a corporate entity.
All right. And I think throughout, well, I know throughout, we've talked about this whole idea about appointing counsel or not, and we haven't done that because you didn't want that. And I remember the times that we've been together. I can't speak for any other judges without looking at their records or listening to their records. So, and the prosecutor's office has been here throughout the times that you've been before the court. And the last hearing, April 8th, was when we cleared up that warrant and we set this hearing. So it's abundantly clear, and that Ty Warren here is speaking for himself or representing himself, and we're going to go forward on that because we've had those discussions for over a year now.
Again, I'm not representing myself or the defendant.
Right, I understand. So I see in the pleadings that you filed that there's at least one. First thing that might be most dispositive is the motion to dismiss based on Court Rule 3.6, which is a suppression of evidence, saying that there was no basis in the law for you to be stopped by the officer. So we're going to start there. Well, I'll make the record here as to jurisdiction and venue. I think I've made that record already, and I don't see anything. I'll hear from the state if there's anything else. And we talked about this at the last hearing, that this is the district court. This is an allegation of a driving offense under RCW 61, also an allegation of obstructing law enforcement. Those are properly filed in this court as they're alleged to have occurred here in Thurston County. And this court has jurisdiction, subject matter, and in personam jurisdiction. So venue is proper as well. So
I'm here to challenge that.
I understand, and that's part of your motions. Just making the record that there isn't any basis in your motions that have undercut that reality. So the court does have jurisdiction and venue is proper. So we're gonna hit that 3.6 motion. And I'm going to hear from the state as to what evidence they have to present. And I'm looking back to that motion. I think it's about 33 pages that was filed back in February and reiterated throughout. So Mr. Thompson.
You're speaking of my affidavit?
Yes. And you've filed a lot of information. I've taken it all together. It starts out with that motion to dismiss from going back to, June of 2024. I misspoke.
You can sum it all up with my most recent affidavit.
Yeah, and that I'm also including in my reading, everything you filed. So now I'm going to jump to the state because they're the ones who have to defend against your motion. I will hear more from you. So, Mr. Thompson.
Thank you, Your Honor. And the sworn statement that our office provided at the initial hearing stands that the defendant was stopped for speeding, and during the course, that was the basis of the stop was speeding.
And so resting on that initial probable cause finding in April.
That was, yes, correct. That was the basis for the initial stop, which would give rise to the Terry stop for an infraction. And from that point on, the defendant refused to give name and gave a world passport ID card or world passport. I don't even know how to fully describe it accurately other than not a document from a government entity.
So anything you'd like to say more, Mr. Warren or Ty Warren?
Yeah, plenty to say.
As to that issue, let's kind of focus in on issue by issue.
What the prosecutor has just said, he stated that I did not give a name, and then he counteracted himself by saying I did give a world passport ID, and then he said it was not a valid or whatever he said, and not valid or not recognized by the state. But whatever the case, I would like to present my what I have to say here. I'm a man visiting here, especially not generally sui juris and trial solely to challenge jurisdiction.
Let me ask you a quick question. Did you already file the information that you're reading?
No.
No, this is new?
Yes.
Okay. All right. You have an extra copy?
This is just my oral.
Okay. All right.
Printed out.
Let's see. Try and focus in on the motion to dismiss that you have for suppression of the evidence.
This is what this is all about. It's all about jurisdiction.
Well, we're not talking jurisdiction.
Proven on the record, and I have seen no proof of jurisdiction.
Talk to me about your motion to suppress. Talk to me about your allegation here.
I'm here to establish jurisdiction or not.
Well, I've already maybe I should be more clear.
There are no facts on the record.
I deny your motion as to jurisdiction in this court. So this court has jurisdiction in venue. What I need to hear from you is what do you have to say about your motion to dismiss for a bad stop?
About a motion to dismiss until jurisdiction has been established.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but you can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive, the stop.
One moment, please.
Sure.
I respectfully object to that ruling and give notice. I contest the court's assertion of jurisdiction all the way. Let the record show that I timely and persistently challenge jurisdiction, and that challenge remains unanswered by factual evidence.
Anything else? Just looking back through your affidavit and your motion. Anything else for me to consider from you?
Like I said, I have plenty to consider.
Okay. About, first off, as to this motion to dismiss based on the bad stop, is what you say.
Yeah. Excuse me?
Your motion to dismiss based on a lack of good reason for the stop. That's what I'm first dealing with.
I can't even address that issue without jurisdiction being established.
Okay. All right. Well, all right, Mr. Ty Warren, Mr. Azeltine, however you want to be referred to. So this is the deal. I'm granting your motion to suppress all evidence after a stop. I have no evidence presented that I can consider. This was filed by you in April of 2024. And there's been affidavits and information filed thereafter, all in the court file. We've set this for trial, or we've set this for motion as recently as April 8th. State was present. It's kind of like, for whatever reason, the state decided not to join or prosecute. So under Rule 3.6, I don't have any evidence to overcome what your assertion is that you were peacefully driving down the street. And simply the probable cause statement from the beginning to allow the set of release conditions is not sufficient. There isn't anything other in the court file, in the court record, that would allow the state to overcome your motion to dismiss or to motion to suppress evidence. So all evidence obtained, stopped forward, is suppressed or not allowed to be brought forward in trial by the state against you. So with that ruling, Mr. Thompson, from the state's point of view.
I believe the court is, well, I have nothing to add, Your Honor. The state will be filing an appeal.
All right. So are you saying that with that order of suppression, state, you're thinking an interlocutory appeal and able to go forward?
Yes, Your Honor. Well, I suspect the court intends to dismiss the case at this point. So I don't think an interlocutory appeal is what will happen, but an appeal nonetheless. You know, again, the state stands by its position that I put into the record regarding his appearance today pro se. I still do not believe that the court has gone through it properly. I will note one additional thing for the record, that in his motion to dismiss, he specifically says that he's doing so under duress, which calls into question the validity of any of his filings. And the reason why the state still believes, even over his objection, counsel should be appointed, because he is not here of his own free volition, as he said more than one occasion in more than one filing.
It's clear to the court he is throughout all of this. The semantics that he likes to use are not persuasive to the court. So, but as I said, the prosecution's decided, not to present. So, as we know, Mr. Azeltine, as we know you as, this matter is dismissed, given that suppression of all the evidence, and you're free to be on your way.
Thank you.
Thank you, sir.
I'm not threatening you. Say one more word and that's 30 days. 30 days.